Back on News Channel 5, our guest with us this morning, News Channel 5 legal analyst Nick Leonardo. We're talking about the aftermath of the George Floyd verdict and how that may set the stage for other similar type cases coming forward. And we have one happening here in Nashville in July. We'll be covering it gavel to gavel along those lines. And, you know, Nick, it's interesting. On Facebook, there are some folks out there that just haven't come to terms yet with this verdict. And they're like, you know, what about, George Floyd's criminal past, or the fact that he may have been on drugs that day, or issues along those lines? Talk about, legally speaking, how, the focus is on the incident that led to his death, correct? These other peripheral things, I mean, folks have rights.
Sure, absolutely. It doesn't matter that you may be a convicted felon or that you may have done some horrible things in the past. Everyone in America is entitled to equal protection under the law. And so there are certain rules of evidence that would allow for prior convictions, prior felonies, and maybe certain crimes of dishonesty and the like to come in as evidence. But again, the past doesn't necessarily matter because everyone is entitled to protection under the law. And so the focus is what happened in those last 9 minutes and 29 seconds of his life. And it's important to point out as well that I heard someone, the criminal law is different state to state. And so I heard a lawyer last night on TV say that they did not have to find, or part of the jury instructions there in Minnesota did not require the jury to find that Chauvin was the sole cause of Floyd's death, but rather he was a contributing cause.
Right.
And so, that's a much lower threshold. I think the prosecution certainly established that. But the fact that someone has a colored past does not mean that they don't have the right to be protected under the law or the right to not be assaulted by their neighbor, by the police, or anyone.
Okay, let's take a call from Taylor. Taylor, good morning. Hi, Taylor.
Good morning, Nick.
Good morning.
Good to have you. I've got mixed feelings on this case. I'm certainly pro-police, but I'm also anti-shooting all the first and asking questions later. So many of these cases, any infraction the deceased may have done is usually not known by the officer when he or she fires the shot, and so that is a problem. One thing about that case, though, in Minnesota, the very main witness was the video. And I think that will be one of the main witnesses in this Hamrick trial that has taken a ridiculously long time to bring to court. In that case, though, yesterday, I listened to the verdict coming in, and they kept guilty of all three. Well, in Tennessee, I think, and Nick can correct me if I'm wrong, the jury would have had to have decided, was it manslaughter, was it second degree, or was it third degree? You wouldn't just come in and say he's guilty of all three, because obviously two of those three would not be correct. So that was a surprise to me.
Okay, if you can, Nick. Laws, Taylor's right, can vary from state to state. And so they were able to come back with 1, 2, 3, none. They came back with all three. Could that happen in Tennessee, to your knowledge?
Well, so the way that, and again, I'm not a licensed practice law in Minnesota,
right,
but typically what I see in the situation is that the state had alternating theories of this case, okay? They had 3 different counts, okay? And so what's going to happen is that they'll all merge into the largest count, okay? Which would be the second-degree murder charge. And so the jury charge would tell them to deliberate the most serious offense first, and if they're hung on that, then and only then would they move to a lesser included offense within that count, okay?
Gotcha.
So each count, the trial court is charged, the judge is charged with making sure that those lesser included offenses are placed in the jury charge. But the way the charge reads, or the instructions to the jury, is you start with the indicted offense, okay? And if you can't reach a verdict, unanimous verdict on that, only then do you move to a lesser offense. And in this case, obviously, they never really moved down to the lesser offenses because they found him guilty of all 3 of the indicted offenses.
Okay, so let's talk about the Delke case, if we can. It's different. There's video. The video in the Delke case, I've talked to a lot of people who have watched it, and some people come away with different opinions on whether it was a justified shoot of Daniel Hamrick or not. Whereas I think, in general, the vast majority of people who saw the George Floyd video said, why is he on his neck for that many minutes? Not a lot of people say, oh yeah, he's doing the right thing there. Whereas in the Delke case, there's more wiggle room, it seems, based on people I've talked to. Different opinions on that. And yet, Delke is charged with first-degree murder, a more serious charge than what Chauvin was facing in Minnesota. And I guess my question to you is why? And two, is it going to be possible when this goes to trial that the jury could come back with lesser included offenses, or is it all or nothing?
That's a great question, and then there's a lot there to unpack. So obviously there are some similarities, okay, in this case. It's all on video, all right? This is neither the Delke case or the Chauvin case is a matter of who done it. We know what happened, okay? And in this case, it is a bit different, though, because, you know, we have, you know, Mr. Hambrick, who has a firearm, right? And he's running from the police. But again, Mr. Delke's charged with first-degree murder. And in Tennessee, that is the premeditated, intentional killing of another human being. And the case law says that premeditation can be formed in an instance, which means, you know, if you take time to draw your gun and aim, then there's a, you know, that's obviously...
It's not like you have to be plotting it for weeks. I mean, in that moment, he decided... I mean, but first degree, they're going to have to convince the jury that he intentionally shot to kill this individual.
Right, and they're trained to use deadly force. You're not, you know, they're not trained to pull out a firearm to shoot you in the leg. Right. Right. Okay. They're trained to, you know, it's lethal force. Okay.
Central body mass.
Right. And so the other thing is that the jury would be instructed on the lesser offenses in Mr. Delke's trial. However, in Tennessee, I think the only other lesser included offense it could potentially be would be a second-degree murder charge, which is the knowing killing of another, because after that you have manslaughter, which is the killing in a heat of passion. After that you have reckless homicide, which is, you know, a reckless activity that ended in a death, and then you have criminally negligent homicide. So again, the dangerous part about this for the defense is that it's clear that there was premeditation on the video, and, you know, and if he intended to kill him. So I mean, it's kind of an all or nothing, I feel. But the only possible other conclusion, and of course I haven't seen the proof, I'm just as a lawyer on the outside from 10,000 feet, not really knowing about the facts, would be that it could potentially be a second-degree charge, that he could be found guilty on the knowing killing.
And both of those obviously are very, very serious sentences if convicted. First-degree murder is life in prison with parole. Second-degree murder would be...
Second-degree murder would be, it'd be an A felony, and he'd be looking at 15 to 25, and actually they would start, you know, he's going to be looking at well in excess of probably 20 years.
Okay, and we know Chauvin, with the conviction on all three, could face, he'll sentence things in 4 weeks or 8 weeks, could face up to 40.
Yeah, and so they talked about Blakely factors yesterday, you know, and so what that is there's an enhancement and mitigating factors that the judge has to look at to determine, okay, you know, what kind of sentence do we fashion here for Mr. Chauvin? Do we max it out to 40? And if they do want to max it out, they have to find certain factors that are present. And so the court says that they wanted them to kind of submit some briefs on this Blakely-Apprendi issue as to what factors you think may be present. And then they talked about the pre-sentence report, that they will have a pre-sentence report writer meet with Mr. Chauvin, and they will provide that to the court. And so the court will have to determine, the trial judge will have to determine what sentence to fashion based upon those factors and the counts of which they were convicted.
Let's take another call. We've got one from T. T, good morning. Are you there, T?
Yes, I'm here.
Go ahead, sir.
Quick question. I noticed in the video of watching this particular murder that there looks to be a sense of evilness in this officer's face. And I've noticed that even when you go back to a Trayvon Martin, even as far back as Emmett Till, there seems to be a sense of hate towards black males in this country. What can we do to change that?
Wow. And you're talking about the George Floyd case.
Yes, but I noticed the evilness. If you look at the eyes as his knee was going into this gentleman's neck, he had no remorse, and even during the trial, there was no remorse. What can we do to change that in this country?
Okay, wow. Well, that's you know, as far as remorse, and yeah, people will perceive different things on an individual's face. I see what he saw and thought he saw with Chauvin. In fairness to when they're in trial, in general, in a lot of these high-profile cases, don't attorneys tell their client not to show remorse or emotion in the courtroom in front of the jury?
Sure, but I think the prosecution had, in their closing argument, the rebuttal, had a great point about, you know, don't discount the common sense witness. You know, and I think that the jury does look at demeanor, and I think in that particular video, when you looked at Mr. Chauvin, I don't want to say that he was enjoying that, but it didn't look, like it was business as usual.
I think so. What T was saying, yeah, he didn't.
And T, as far as the other comment, I mean, I think that the best thing that we could do, I think we're all ambassadors of race relations, and I think that the more that we could get to know people who don't look like us, don't talk like us, and don't come from where we come from, and we broaden our horizons, the more that we see people for who they are, and that is individuals and people that resemble someone that we know as a friend. Yeah. And I think that's probably one of the things that we can do. But again, we have to keep pushing forward. We need police reform. And again, this was a victory, but we have to remember that we have to keep pushing these forward and these prosecutions forward until we can get some kind of legislative reform on the way that we're policing.
Take a break on that note, and we come back. More of your phone calls, more of our comments that were coming in right now on Facebook with News Channel 5 legal analyst Nick Leonardo right after this.